Picture this. You're living in medieval England. Life is tough, but you're making it work. You've got a small plot of land, a family, and maybe a few chickens. Then one day, a local official knocks on your door. He's not here for taxes. He's here to tell you that you've been outlawed. Your life, as you know it, is over. What did you do? Murder? Treason? Nope. You simply failed to show up for your court date. Welcome to the bizarre and terrifying world of medieval outlawry. This wasn't just a slap on the wrist to skip in court. This was a legal declaration that you were no longer a person in the eyes of the law. You were, quite literally, a wolf's head, meaning anyone could hunt you down and kill you with complete impunity, just like a wild animal. It sounds insane, right? How could something as simple as missing a court appearance lead to a death sentence carried out by any random person you meet? Well, let's dive into the strange logic of the medieval legal system. Back then, there wasn't a modern police force. If someone committed a crime, it was up to the community and local lords to bring them to justice. The entire system relied on people showing up to court when summoned. If you didn't appear, it was seen as the ultimate act of defiance against the king and the law of the land. It was considered an admission of guilt, even if you were completely innocent. So, how did the process work? Let's say your neighbor accuses you of stealing his pig. A summons is issued. Maybe you never received it. Maybe you were sick, or away on a trip, or maybe you were just scared. It didn't matter. After you failed to appear at 4 consecutive county courts, a process that could take several months, the final judgment would be declared outlawry. The moment those words were spoken, your world turned upside down. Your property, seized by the crown. Your family, left with nothing. Your legal rights, gone. You couldn't sue. You couldn't testify. You couldn't own anything. You were a ghost, a non-entity. Even helping you was a crime. Giving an outlaw food, shelter, or even a kind word could land your friends and family in serious trouble. The official term was caput lupinum, or wolf's head. This phrase wasn't just poetic. It was a literal instruction. It meant your head was no more protected by law than that of a wolf. In the early days of this law, anyone could kill an outlaw on sight and face no legal consequences. In fact, they might even be rewarded for it. Later on, the rules were slightly modified, requiring the outlaw to resist capture before they could be legally killed, but the danger was ever present. You were a walking target. You might be thinking of Robin Hood, the heroic outlaw of Sherwood Forest, stealing from the rich and giving to the poor. While the legends are fantastic, the reality for most outlaws was far from glamorous. They weren't noble heroes living a life of merry adventure. They were desperate, isolated individuals, constantly on the run, hiding in forests, swamps, and wastelands. They lived a life of constant fear, starvation, and paranoia. They couldn't trust anyone. Every stranger was a potential bounty hunter. Every rustle in the leaves could be someone coming to claim their head. Let's look at some real stories. We have records from the time called heir rolls, which are basically court documents from traveling royal justices. They are filled with tales of outlawry. One man, named William, was outlawed for robbery. He was later found and killed, and the court records simply state the fact, no questions asked. Another story tells of a group of men who were outlawed and then hunted down by the local sheriff. Their lives ended not in a heroic battle, but in a desperate, bloody skirmish in the woods. Women couldn't be outlawed in the same way as men, because legally they weren't considered full members of the community to begin with. Instead, they were waived. The result was essentially the same. They lost all their legal protection and property, and could be killed without penalty if they resisted capture. One famous case is that of Alice de Long P., a wealthy noblewoman. When she was involved in a property dispute, her powerful opponents managed to have her waived. She had to flee and live as a fugitive until she could get a royal pardon. If a powerful aristocrat could fall victim to this, imagine the chances for a common peasant. So, was there any way back? Could an outlaw ever rejoin society? The only hope was a royal pardon. But getting one was incredibly difficult. You'd need powerful friends to plead your case to the king, and you'd likely have to pay a hefty fine. For the average person, this was next to impossible. You had to prove that your initial failure to appear in court was for a legitimate reason, which was hard to do when you were a hunted fugitive. Some outlaws tried to survive by forming gangs, which is where the Robin Hood connection comes from. These gangs, like the famous Fauville gang or the Cotterell gang, weren't exactly fighting for social justice. They were often brutal criminals, using their outlaw status as a license for theft, kidnapping, and extortion. They became a major problem for the authorities, essentially operating as local mafias. They would terrorize communities, sometimes even being hired by nobles to carry out their dirty work and intimidate rivals. The law of outlawry reveals so much about the medieval mindset. It shows a world where community and obedience to authority were paramount. The system was designed not just to punish crime, but to enforce conformity. To step outside the legal framework was to cease to be human in the eyes of society. It was a tool of social control, and a terrifyingly effective one at that. This brutal practice didn't just disappear overnight. It gradually evolved. As the legal system became more centralized and sophisticated, with better methods for tracking people down, the need for such an extreme measure faded. By the 15th and 16th centuries, killing an outlaw on sight became illegal, and outlawry transformed into a more procedural legal status, stripping rights, but not sanctioning murder. It remained on the books in England as a legal concept for centuries, a fossil of a harsher time, until it was formally abolished in the 19th century for civil cases and the 20th century for criminal cases. So the next time you get a jury summons or a court notice in the mail and think about ignoring it, just take a moment to be thankful you don't live in the Middle Ages. What's now an inconvenience could once have turned you into a wolf's head, running for your life in the dark forests of medieval England, with your whole world destroyed over a missed appointment. It's a chilling reminder of how far our concepts of justice and human rights have come. Thanks so much for watching. If you found this dive into medieval law fascinating, make sure to hit that like button and subscribe for more strange stories from history. Let me know in the comments what other bizarre historical laws you'd like to hear about. See you next time.